Welcome, everyone, to another episode of the SERMAPod. This is the podcast for the Sports and Entertainment Risk Management Alliance. I am your host and also the founder and CEO of SERMA, Rich Lenkov, and we're very privileged to have a special guest today. Julie Hopkins is an attorney with her own law firm, Hopkins IP. She is also an adjunct professor at the University of Maryland, Carey School of Law, and she's here to talk to us today about a very interesting application for trademark protection by the Baltimore Ravens. Julie, welcome to the SERMAPod.
Thank you so much for having me.
Well, the Ravens are a NFL football team, and they are trying to protect the term Charm City. Now, they have applied for protection specifically for its use in terms of marketing and selling themselves as a football club. But that trademark rejection or application was at least initially rejected because it was considered too broad. The term Charm City is used by many other people and entities, so it was rejected. Talk to us, first of all, about the application process and what they were looking to do in filing for this protection.
Sure. So they filed a trademark application with the U.S. Patent and Trademark Office for Charm City. And when you file a trademark application, you have to identify the goods and services that you're going to be using in connection with the mark. And so they identified a number of things from clothing to trading cards, pennants, but then also entertainment services related to, professional football games. So it was not Charm City in connection with everything. It was narrowly tailored to specific goods and services. And they even said specifically for the promotion of the Ravens professional football team. So they limited it even further, specifically to be a mark used in connection with their football team.
So is this just a document that you file? Is there any evidence that's applied? Is there testimony? What's this application process look like?
Sure. So they filed an intent to use trademark application, which means they're not using the mark in commerce yet. In commerce means you've had sales of goods that are listed in the application, or you've rendered the services listed in the application. So they filed an intent to use application, and that just requires you to identify the mark that you want to use and the goods and services you're intending to use the mark in connection with. So there's a declaration you sign in connection with that says you have a bona fide intent to use it in commerce. But at this stage, because it's an intent to use application, they did not need to submit any evidence of use, any dates of sales, that type of thing. That would come later down the road. Trademarks do not register with the U.S. Patent and Trademark Office unless they've been used in commerce. So down the road, they would have to submit that evidence and show that proof that they are using it in connection with the goods and services that they listed in the application.
And what's the goal of a company like the Ravens applying for this protection?
Sure. So trademarks, are enforceable against trademark infringers. So anyone who would use a confusingly similar mark, so a mark that's similar in appearance, and used in connection with similar goods and services, related goods and services. If they had a registration, they could enforce it against those infringers. And so I would imagine for the Ravens, that could potentially be people selling, counterfeit or knockoff goods, T-shirts, clothing, that type of thing. I would imagine they're not trying to go after other Charm City businesses in Baltimore. I will tell you that there are a number of businesses that include Charm City in their trademarks and in their businesses, unrelated to football. So I don't imagine that's what they're trying to do. I would imagine it'd be more trying to stop, people selling competing goods, potentially, counterfeit or knockoff goods.
So, Julie, the NFL generally and its teams are, they represent some of the strongest IP in the world, right? Some of the most recognized and most protected brands in the world. You would think, to a layperson, would think, like myself in this area, would think that the NFL covers anything that their member clubs sell. In other words, if the Ravens were selling goods and products with the term Charm City on them, why aren't they under the umbrella of the NFL protection?
So that's an interesting question. I don't know. I mean, the Ravens have their own business entity. They filed the application under their business entity. So there's probably licensing deals. I know that, I did see in my research that some of the Charm City clothing is being sold on the NFL website as well as on the Ravens site. So I imagine there's some sort of agreement or licensing deal going back and forth to enable that. But as far as the decision as to who owns which trademark, that I'm not entirely sure about. But I do know this one was filed specifically by the Ravens organization.
All right, so it was filed and then it was rejected. Talk to us about the reasons surrounding the rejection of this application.
Sure. So once it's filed, it's reviewed by a trademark examiner, and the trademark examiner rejected the mark as being geographically descriptive. So a trademark is not registerable on the principal register if it is descriptive of the goods and services that are being that are listed in the application, or they're geographically descriptive, meaning they're indicating a specific location and the goods or services emanate from that location. And that extends to nicknames. So nicknames for certain, for cities, for states, for locations, the Trademark Office views those as geographic descriptors. However, it has to be recognized by the American public to be a geographic descriptor and a nickname. So this was rejected because Charm City was determined by the examiner to be a well-known nickname for the city of Baltimore. And so that was why the mark was rejected.
And I imagine the reason surrounding the idea that you can't basically own a geographical location is because you're, preventing so many other businesses from using that that name, and it's not fair given how widely used a particular moniker might be in a geographic location.
Yeah, that's exactly right. The policy is that you want other businesses to be able to identify where their goods and services are coming from. So it's to allow other businesses to be able to use the name as well. So that's the issue there. It is possible to get a trademark with a geographic indicator in the mark. You just have to the term is acquire distinctiveness. So if you've used the mark in commerce in connection with your business, with your goods and your services for more than 5 years, that's kind of the magic number. If you've used it for 5 years or more, you can state to the Trademark Office that you've acquired this distinctiveness, meaning consumers recognize it as a brand as opposed to just a geographic indicator. And at that point, it would be registerable on the principal register with the Trademark Office. So there's actually a number of Charm City businesses that have registrations with the U.S. Trademark Office. But they've been using them for 5 years or more.
So in the application, Julie, the Ravens list a number of products that they're selling already and that they intend to sell with this Charm City name on them. Talk to us about, how listing those products influence the decision, because as far as I understand, the more broad you are, obviously, the less likely you're going to get trademark protection because you're going to prevent all these other businesses from using Charm City. But in the application, they are listing things like footballs that are unique to the Ravens, but they're also listing things like calendars, which if I'm a calendar maker in Baltimore, I'm going to object to the Ravens, monopolizing Charm City on calendars.
Yeah, so it's all about a first-to-file system with the Trademark Office, and a priority as far as who's using the mark in connection with the good or the service first, and that's the person or the business who gets the trademark rights. So the Trademark Office the examiner conducted a search to see if there were other pending applications or registrations that were filed or registered in connection with identical or similar related goods. And the examiner did not identify any other applications or registrations for example, calendars. So the Ravens were essentially the first to file in connection with that good. As far as, but keep in mind, they filed it as intent to use, meaning that they have not actually sold calendars. They may have, but I didn't see anyone. I did some research. So they're intending to do that in the future. As far as a current, calendar seller that hasn't filed a registration, they have common law rights. Those are rights that attach the moment you start selling a good in commerce. They're enforceable. They're just limited geographically. So certainly, if there's a calendar company they've called themselves Charm City or they have Charm City in their name, they could certainly go after the Ravens for trademark infringement in the event the Ravens started selling calendars under Charm City and this other company had the common law rights first.
Got it. That's really interesting. So
yes.
What's the confusingly similar standard? The Ravens could protect their mark if there's others using it, and they can prove this confusingly similar standard. That sounds like something that's confusing in and of itself. So,
yeah. So a mark is not registerable with the U.S. Patent and Trademark Office if it is confusingly similar to another mark that is already pending or registered. So the standard is basically, would a consumer be confused as to the source of the goods or services based on the mark and the goods and services that are being offered. And so it's a multi-factor test. The two most important factors are the similarity of the mark in sight, sound, and meaning. So how is it spelled? What does it look like? How identical is it? Is it pronounced the same? Does it have the same connotation? And then the second factor is the similarity of the goods and services. So again, they don't have to be identical. They just have to be related. So is it likely that a consumer would see that those goods are emanating from the same store, on the same shelf at the grocery store, that type of thing? So that's the test for confusingly similar. There's about 6 or 7 factors, but the two most important ones are the similarity of the mark and appearance and the goods and services.
And Julie, if the Ravens don't succeed, they could try on a supplemental register. This was applied for on the principal register. Could you explain what those two things are and how they're different?
Sure. So for a mark that is deemed to be descriptive by the Trademark Office, or here geographically descriptive, if the mark is being used in commerce, you have the option of putting it on the supplemental register. So the principal register is the one that we always think about. It has all the rights that you get when you have a trademark registration. The supplemental register is only really for marks the Trademark Office deemed to be descriptive. And so it sits there. You get to use the circle R, which is, a deterrent often to potential infringers. You can sue in federal court for trademark infringement. It's also searchable, so it would prevent another mark potentially from coming along and being registered subsequent to the Ravens. But there's no presumption of validity. So again, it's an admission that you haven't acquired this distinctiveness. So you would still, if you were to enforce it, you would have to prove that it is functioning as a trademark as opposed to being a descriptor. So the Ravens had an option, if they were in use in commerce for the goods and services, to have the mark register on the supplemental register instead of the principal. But as I said, they filed as intent to use. So they would have to amend the application to be in use. They'd have to then prove they were using it in connection with the goods and services. They certainly could delete out the ones that they weren't, they didn't have sales for yet, and then put it on the supplemental register. And then after 5 years of sales, then they could have it moved to the principal register.
So is there an appellate process? Where does the case currently stand? Are they appealing the rejection? Is that possible, or what's the next step?
So you have 3 months to respond to the office action, and that's not an appeals process. That's just a back and forth with the examiner. And so the office action issued on December 6th. So they actually had until March 6th to respond. And from what I can tell, they did not do so. So it looks like this application is going to abandon. So yeah, they have the option to either argue that Charm City is not a well-known nickname for Baltimore, or they could have proven that they were using the mark in commerce with some of the goods and services and then amended to the supplemental register. But they actually, from what I can tell, I guess it's been 10 days, 11 days since the deadline. Usually it's posted online if they had responded by now. So it looks like they did not take either of those options, and the application is going to abandon.
So, Julie, last question here. I'm sitting in the Windy City, and that's a very well-known nickname for a city. People actually confuse that one because they think it's because Chicago is windy. It is windy. It's very windy today, but actually that nickname was because of back in the day, politicians were blowing a lot of air and were very, boisterous about their claims. So that's why it became the Windy City. I think Charm City is fairly well known, maybe not so much out of Baltimore, but I don't know the originations of that nickname. I assume you do, being that's your hometown, right?
Yes, I'm from Baltimore. So my understanding, it was a PR campaign to try to make Baltimore seem like a more welcoming place. I think it was back in the 80s that it originated. So yeah, it's been a nickname for Baltimore for quite a while now.
And then The Wire came along, and Homicide Life on different.
Yeah, Baltimore's always trying to improve its image.
Well, Julie, thank you.
It's a great place. I will tell you, it's a great place.
Well, yeah, it's a great city, great food, great people. It's Julie Hopkins from Hopkins IP. Thank you so much for joining us on the SERMAPod.
Thank you for having me.